Alicia and Charles, if you're ready, we'll go ahead and I'll start with some introductions here and then we'll get going. Take a moment here as people are still joining us. We have over 100 people that have joined our call here today. So thank you, everybody, for being here. And hi, everybody. Thank you for attending our short-term rental piece here today of the 2021 Joint Planning Conference of the New York State upstate chapter of the American Planning Association, the New York Planning Federation. My name is Doug Finch. I'm a board of directors member of the New York Planning Federation and town manager of the town of Canandaigua. So before we get started, we'd like to thank our conference premier sponsor, Hodgson and Ross, and the sponsor for this session on short-term rentals. Without our partners, the virtual conference just would not be possible. We want to let you know that all of our sessions are being recorded and will be available online through the conference page. Links will be provided on the Eventbrite event page as videos become available and are posted. I'll also be posting some additional information through the chat box and links as we continue. All attendees are automatically muted. If you have any questions, please submit them in the Q&A box. We'll address questions after the speaker at the end of the session. We're providing the session CM credit number 9221234. We'll put that in the chat box with a link so that you have additional information. And I believe this session is 1 CM credit for those of you looking for that. For attendees seeking Planning and Zoning Board credit, you'll receive an email confirmation confirming your attendance and sessions eligibility for Planning and Zoning Board member training credits about 24 hours after the event. Viewing the webinar recordings are also available for CM credits and may be eligible for Planning and Zoning Board member credit. Planning and Zoning Board members should check with their municipality to confirm eligibility. So I'm super excited about today's session. It's on short-term rentals, regulating short-term rentals. This is certainly a hot button topic for many of us. I know with my municipality, it's something that we're dealing with, and I'd like to welcome Charles Malcolm and Alicia Leglin. Chuck is a partner at Hodgson and Ross in Buffalo. He concentrates his practice on environmental law, energy law, land use law, municipal law, real estate development, and legal issues involving industrial development agencies. His experience working with private and public clients on matters involving both state and federal environmental statutes and assists municipalities with a wide range of legal issues, including environmental review and zoning. Chuck has extensive litigation experience related to all areas of practice, both at the administrative, trial court, and appellate levels. He also focuses on seeker, where his extensive experience guiding municipalities and developers through its requirements. Successful projects include environmental assessments for large-scale telecommunication projects, power generation projects, including some of the largest wind farms in the eastern U.S., and both utility and small-scale solar projects. Infrastructure improvements and public and private developments from project inception through successful litigation. And we have Alicia with us also today, an associate at Hodgkin and Ross in Albany. She's a member of the firm's environmental, renewable energy, land use practice. Her experience and current work centers on environmental law, energy law, land use law, and zoning law. A primary part of the practice involves preparing zoning analysis for renewable energy developers, representing clients in Article 78 proceedings, and assisting clients with regulatory compliance matters and environmental due diligence review. Thank you so much to both of you for taking the time to speak to us today about this subject. It's certainly something that everybody is very interested in. We've got a lot of participants. And Chuck, I'll turn things over to you.
Thank you very much, Doug, and it's a pleasure to be with everybody here this afternoon virtually. And I think you hit the nail right on the head when you said that this was a hot button topic. I know from my practice, we've kind of been through the trenches on this a few times, and it brings together kind of a lot of elements of land use law and planning, from the comprehensive plan approach to the actual development of an ordinance to enforcement. And, we can talk about each one of those things as we go through this presentation. So just as a roadmap as to what we're going to do today, we're going to start with kind of an overview of the topic, why this has become such an issue, what some of the developments are in the law, some interesting kind of, nationwide efforts to deal with these issues, some interesting stories just to kind of set the table. And then we're going to take on, some efforts to deal with these issues and some of the tools in the land use municipal toolbox to kind of grapple with some of these issues. And we'll look at some of the case law as to how some of these things have played out. how courts have looked at these things both before and after these laws have been developed and implemented. And we'll go through some best practices and some thoughts to consider as communities navigate these issues. And with that, I'll turn it over to my colleague Alicia, who's going to kick us off.
Great, thanks, Jack. Okay, so let me share my screen with you all. Bear with me with just a moment. Okay, how does that look, Chuck? Thumbs up, we're good? You say okay. All right, great. Let's get started. As Chuck said, it is a pleasure to be here with you all today to talk about short-term rentals, which I know everyone is curious about. So basically, this kind of stems from the sharing economy. The sharing economy, it's pretty popular now with a lot of things other than just short-term rentals. So it's peer-to-peer exchange of goods, usually a focus on underused goods. You have that spare room that you can rent out. That's a lot of times how an Airbnb gets started, or selling old things that you don't need anymore. And these bigger companies basically just provide the platform.
Hey, Alicia, I'm sorry to interrupt you here. We're getting some comments about your sound, your microphone, that it's really garbly and it's kind of hard to understand.
Can you hear me better now?
I think that's a little bit better, it sounds like, yes.
Okay. I'll just kind of bring the volume all the way up. Okay, there we go. I think that might be better. All right. So back to the sharing economy. So basically, it's these big companies are connecting users, just creating the platform using big data and creating apps that allow this to just be used so easily. So some examples that we're all incredibly familiar with and have become incredibly familiar with over the past few years, things like Uber and Lyft. That's a great example. We all use those when we're traveling these days. Sharing services like TaskRabbit and Care.com, selling and buying gently used goods like Poshmark. I personally am a fan. I've used that. We've all used a lot of these things, Airbnbs, HomeAway is what we're going to talk about today, and co-working spaces too. That's a big thing, a big trend that has come up in recent years as well. Okay, so what are short-term rentals? Basically, they're also called vacation rentals. It's a tenancy for less than 30 days in what is traditionally a residential unit. And they're marketed on these websites like Airbnb, and they're marketed by the owners or the tenants sometimes. And people can just go on the app or go on the website and scroll through a bunch of listings. And a lot of times they are actually cheaper than hotels. So I had found an interesting example, just decided on a city, like Portland, let's see, what we can find. So I went on and looked, I found an Airbnb for $150 versus a nearby hotel was right in the same like downtown area for $205. So you can find these, cheaper options like Airbnb. So how did Airbnb specifically come about? Basically in 2007, two roommates in San Francisco, which, the rents in San Francisco are crazy. So they were having trouble making their rent. They put a couple air mattresses in their living room, opened up a bed and breakfast. So the next year they actually started this company because they realized what a great idea. And then, incredible success. And in 2020, they went public. So millions and millions of active listings, 100,000 cities, over 200 countries. So we all know that the success of Airbnb, it's pretty phenomenal. And the accommodations can be, someone just rents out an apartment, or you can rent out crazy things like a private island. So it's a very interesting platform. So some interesting listings that we found on Airbnb, actually, we have a couple of good examples here. So one is a official global model Earthship is what it's called. It's basically just, fully sustainable home. Basically, it's, generates its own energy, grows its own food, all that kind of stuff out in the desert, basically in New Mexico. So a very natural experience for people who are interested in that kind of thing. So that would be very fun. Something pretty similar out in Colorado. There's a Adobe Dome that you can actually rent. It's a 1 bed, 1 bath. So another really cool natural experience for people who are looking to vacation a different way. And it's out near Sand Dunes National Monument. So that's definitely a big draw for people, I'm sure. And then another one closer to home here in New York is a 1810 hay barn up in the Finger Lakes that was actually converted into a beautiful Airbnb in a nice rustic spot. So people love this kind of thing in upstate New York for sure. So I'm sure this one is quite popular as well. And then another really interesting example, last one here, was someone turned a shipping container actually into an adorable little rental spot. Going through the pictures, it actually looked like one of those cute little tiny homes on the inside. So this is a great example of reusing a really interesting thing and turning it into a cute little rental. And it's near a bunch of big tourist attractions, so it's definitely a good option for people, and certainly completely different than the traditional hotel type stay. So this is very classic Airbnb. It's very cool. So as we said, we all know Airbnb's growth over the years has been pretty great. They're certainly steadily increasing. They even rebounded pretty well after 2020, which, for hospitality was a terrible year, obviously, but they're even still doing well in 2021. Very popular. So short-term rentals in general, there are, of course, there's benefits, there's drawbacks. The benefits are, first is the additional income. So property owners definitely make more money doing the short-term rentals and the long-term rentals. So it's certainly an attractive option. Just looking at Airbnb data, their hosts earn just under about 10 grand a year, the average host. So certainly bringing in that extra money. Also, guests who stay in Airbnbs tend to stay longer. They contribute to the economy of the municipality. The downtown areas of big cities, like the tourists typically go there, they're contributing to that economy. When you have an Airbnb, maybe they're staying out in the suburb of the surrounding city, less people, less traffic. So they're generating some business there, which is always a benefit. And they tend to, when they stay longer, they spend more money. So that's always good for local businesses. So those are certainly benefits to short-term rentals. But of course, there are drawbacks as well. And this is where a lot of the headlines come from. So again, short-term rentals are called vacation rentals for a reason. People are out, they're away, they're having a good time. So they don't necessarily treat the accommodations as they would their own home, a friend's house, things like that. So there are certainly impacts to neighbors that can come up, noise, traffic, trespassing, crime, safety, all those kinds of concerns. And a lot of local residents also get concerned about increase in rent going up. That's certainly something that cities have seen, and we'll talk about in a little bit. And it also kind of changes a residential community into something else. So if you're renting out all of these units short-term, like a hotel, well, a hotel is a business. It's not a residential community. So what exactly is it? So these are all certainly concerns that have come up. And a lot of times the opposition, the craziness over short-term rentals come from neighbors and all the issues that they're facing. So additional problems, some of like the crazy headlines you hear about short-term rentals, people putting cameras in the units. Someone was arrested for that. It's just like, a guest on Airbnb, your worst nightmare to find something like that. But things like that have certainly happened. These huge house parties that end up happening when people rent an Airbnb for the weekend and tons of people will show up, and of course it's just ruckus and blocking the road and loud music. These headlines we've all seen over the past few years. And then sometimes this can happen too, where an Airbnb renter will just refuse to leave, and then the host will have to go through eviction proceedings. And of course, that's the last thing they thought that was going to happen with a rental for a few days, but it has happened. So these are certainly drawbacks to short-term rentals, as well as there are positives. So before we get into some examples of municipalities' efforts to regulate short-term rentals, we can look internally. Airbnb actually did come out with a whole host of responsible hosting policies, which basically it's their effort to kind of get Airbnb hosts to, meet certain requirements to improve all of the issues that they were seeing. So things like health and cleanliness, especially with COVID, safety and anything with neighbors, making sure, they're parking in the right spots and there's, restrictions as far as making too much noise at certain times, just being good neighbors, making sure any permissions are received, any insurance if it's needed. And Airbnb actually, as part of this effort, has a really good resource on their website that it lists like any imaginable municipality where Airbnbs are pretty popular. And you can click on that municipality and it'll bring you to all of that municipality's local regulation on short-term rentals. So it connects you to what you need to know as far as the host abiding by the local rules for short-term rentals. So it's actually pretty comprehensive. So with that, we can start with New York City. So New York City was the biggest city to first really kind of get into it with Airbnb. There were a lot of issues going on. So basically, New York City was seeing Airbnb hosts just dominating the rental market, and they were avoiding a lot of requirements in New York City regulations. So they were making a ton of money. They were displacing long-term renters because the rents were going through the roof. And they started realizing that, like, okay, I have a big building, I can rent a bunch of these out short-term instead of renting them long-term. A lot of turnover, they were making a bunch of money, but technically they weren't able to do that. So we can talk about why. So basically these Airbnbs were violating New York's multiple dwellings law, specifically for Class A multiple dwellings, because it was prior to 2010, it was defined as a multiple dwelling used for permanent residence. Then, following a bunch of litigation in 2010, it was amended to specify what does permanent residence mean, and that meant at least 30 consecutive days. So basically, an apartment that was being in a Class A multiple dwelling apartment that was being rented out for less than 30 days was violating multiple dwellings law. So that was the big issue that the city was facing and had to deal with at the time. So as of this year, New York City also decided to go the data sharing route. It wanted to understand who is hosting, where are these apartments located. So now, as of this year, 2021, there were data sharing requirements for Airbnb hosts. So basically, there was through a city ordinance that was passed requiring certain information about the host and the rental listing, and it'd be shared with the city. And there were some exemptions for that. Of course, rentals for 30 nights or longer, not a short-term rental, so the city's not really concerned about that. Same thing with the Class B. Multiple dwellings, again, that wasn't where all the issues were happening. Hosts who don't really rent that often, for 4 or less nights per quarter, again, the city is not that concerned. So there were some exemptions, but basically Airbnb hosts have to provide a bunch of information to the city. So the city's keeping an eye on what's going on. And then some other regulations that New York City has passed to kind of stay on top of this. They regulate the advertisements for these rentals. Sometimes business licensing is required, depending on the rental. There are also a whole separate list of rules and regulations if the unit at issue is rent stabilized and rent controlled. And there's also a bunch of tax implications. City and state taxes might apply. So, New York City didn't solve the short-term rental problem. They certainly were one of the first to start addressing it. So they still are, deeply concerned about the local hotels, the traditional hotels, bed and breakfasts that, dominate the industry like used to. They're definitely still concerned about their longevity. And because Airbnb is just a completely different beast. It's totally different than the normal business model for hotels. So city officials are constantly thinking about additional regulations, legislation, even going the tax route to see what they can do to kind of keep these short-term rentals in check in the city. So going forward, New York City is definitely one of the ones to watch. I mean, it's such a huge city. It's immensely popular as far as tourists. So, keeping an eye on how they're regulating that vast amount of traffic in and out of their city with short-term rentals is going to be crucial really for any municipality to see, additional techniques and kind of what they do. So we will see. So another big one that has gotten into regulating short-term rentals in San Francisco, the hometown of Airbnb. Initially, when Airbnb came out, there were some mixed feelings. Some people were pretty, excited about the potential to bring in that additional income, but others were worried about, like, we already can barely afford to live in San Francisco because it's so expensive. Is rent going to go through the roof, and then we're all going to be out of our apartments. So San Francisco kind of came up with a way to balance all of these concerns, and it actually did a fairly good job, as we'll see here. So firstly, short-term rentals in San Francisco, the hosts need business registration certificates as well as short-term residential rental certificates. So the city is fully involved in short-term rentals. They're keeping an eye on what's going on. So hosts have to also be the primary resident, meaning that they have to live there for at least 275 days a year. And there's requirements for liability insurance. Similarly to New York, there are specific restrictions on buildings, units that are rent controlled, rent stabilized. And actually the building department in San Francisco gets involved as well, making sure that certain rules and regulations are followed as far as, maintenance of the building, construction, health and safety, all of that kind of stuff as well. So again, similar to New York City, there are, reporting and record keeping requirements. There are also safety requirements that the city requires. The city also collects the transient occupancy tax for short-term rentals in San Francisco. But interestingly, Airbnb and other platforms that are just comprehensive in this manner they kind of take care of this requirement. So they'll collect that tax from the host and then remit it to the city. So that is kind of a helpful thing for hosts. But San Francisco does collect that tax. And they also pass an additional rent ordinance that, although not specifically about short-term rentals, though definitely involved because this was such a concern, it basically prohibits landlords from evicting tenants without just cause. So that came out in San Francisco as well. So basically the way San Francisco was able to regulate short-term rentals was by doing a few different things together, and it was really successful. So amending the outdated laws, because short-term rentals, this whole Airbnb thing is fairly new, and old codes, old laws just don't address it the way that they really could. Enacting new requirements, and then they also created a special regulatory board to kind of keep an eye on things and have just a dedicated group of individuals dealing with this, paying special attention to it. So these three things together made these rules and regulations very effective. And a lot of people think that San Francisco can serve kind of as a model for how to deal with Airbnb and other short-term rentals. So LA is another similar example of a city in California dealing with serious, housing shortages and housing crisis. So a few years ago, lawmakers in LA started thinking about how to regulate short-term rentals to deal with this, because similarly to New York, big building owners were looking at their units saying, I can rent a ton of these out for weekends or a week, and high turnover, I can make a fortune rather than, renting each one out for a year or 2 years. So that jacked up the rental prices in the area like crazy. And there was already a housing shortage. So it was just a big problem. So LA lawmakers really needed to get involved here. So that being said, in 2019, LA came out with the home sharing ordinance, which basically, one, requires that hosts register with the city. So again, these cities are keeping tabs on what's going on. And they have to post that registration in the listing. And the unit has to be their primary residence. And they can only, just like any short-term rental, it can only be for 30 days or less. So basically in LA, because every municipality is different, the language is different. In LA, a little bit different than in San Francisco, primary residence means for more than 6 months, instead of the 275 days a year. The registration lasts a year. Again, this one is different too, compared to New York and San Francisco, that if the residence is rent stabilized, it's just it doesn't apply. You can't, the home sharing ordinance does not apply. You can't do that. Additionally, if the host is a renter, written approval from the owner is required. And then same thing with the transient occupancy tax, that applies as well. So here in LA, to rent out a secondary or a vacation home, the listing has to be 30 days or more, because they don't fit into this category of primary residence. So additionally, home sharing in LA can only be for 120 days per year. If a host wants to rent out for more than that, they would have to apply for extended home sharing, which they would just have to meet additional requirements. So their registration must be clean, can't have been, suspended or revoked or have any citations. And there's also an interesting component here where the neighbors have to be given notice, because like we've said, and like we'll continue to talk about, the biggest issues with short-term rentals typically are fights with neighbors. They're being impacted in one way or another. So this is kind of addressing that situation head on by requiring the application for extended home sharing to notify their neighbors that they're going for that. And then again, similarly to New York City, with the data sharing requirements, LA is the same. So certain short-term rental listing information has to be shared with the city. Basically, the city's trying to ensure compliance with the ordinance, and it applies to listings that are registered or claiming an exemption. So some other examples, these two municipalities are from Washington State. So Clyde Hill addressed short-term rentals through its municipal code. So these are two examples of how that works. So Clyde Hill defined short-term rentals in its municipal code as a rental of a dwelling for less than 30 days. And it also requires property owners to get a permit, a business license, and that these properties that are going to be used for short-term rentals to meet minimum safety standards. So that was addressed through their municipal code, and Spokane is pretty similar in that way. But an interesting thing about this municipality is that they decided to split their definition of a short-term rental into two different kinds. So they have a type A and a type B. The type A requires an administrative permit, and certain things aren't allowed, like commercial meetings. They prohibited that there. Whereas the type B, that one requires a conditional use permit, and certain things are allowed, like the commercial meetings. So they decided that certain short-term rentals they didn't want in certain areas, so they split it into two, which was an effective way to do that. And then a couple of examples here show how helpful having like a comprehensive website is for regulating short-term rentals for municipalities. So two different examples here from Colorado. One in Boulder, they have a short-term rental webpage, which basically includes the license application packet. So everything that they would need to file with the municipality is all there, all the information that they would need, and the explanations of everything. Then in Durango, they have a vacation rental information webpage, which is definitely helpful there because they have a pretty strict rental code with a lot of different requirements, but they have it all laid out and explaining it to people. So this is definitely a great way to put the information out there, have people be able to access it, just to increase compliance, so the information is out there and accessible. So cities in the US are certainly not the only cities dealing with this issue. And certainly not the only ones who have developed rules, regulations to address some of these problems. So Barcelona, they have a law there that basically says that short-term rentals are considered tourist households, and they require them to be registered, and that advertisements include this registration number. So again, the city is just kind of keeping tabs on things that in short-term rentals and what's going on there. Reykjavik, they have even more regulation, a lot of thresholds, which is interesting. So in Reykjavik, people can rent out their apartments for up to 90 days per year. And again, in periods of 30 days or less, before they would require a hospitality license. And there's also an income cap. So you can't earn higher than a certain amount based on from your short-term rental, which is interesting. That was pretty unique to this city. So prospective Airbnb hosts still need to get registered, and they have to meet certain health and safety regulations for that. And any host that wants to exceed any of these thresholds would be considered a general accommodation service and would then need an operating permit. So there's a lot of levels, a lot of moving parts for that one, but it does make sense, and it is laid out pretty well. So it's a good example of a very tight regulatory framework. And then in Amsterdam, short-term rentals are divided. This is another example of dividing the definition. Basically, you can qualify as a private vacation rental, a bed and breakfast, or a professional operator. And either way, you would have to be registered. And this year, it was amended that all of these would need permits. So these are some examples of efforts to regulate short-term rentals worldwide. Okay, and with that, I'm going to turn it over to Chuck.
So we're going to try and bring it a little bit closer to home here. You know, the Reykjavik one, I put that in there because I actually stayed at an Airbnb in Reykjavik, and it was actually a great experience. It was much better than staying in a hotel. The hotel's rooms there were pretty small. It was great being in the area, in the community, and I like telling people I stayed at an Airbnb in Reykjavik. So there you go. Alicia, if you wouldn't mind just giving me the thumbs up if you can see my stuff. Okay. So where I'm going to pick up is on the issues with regulation. And I saw there were a couple of questions. I'm going to try and cover, I think, a lot of those grounds here. But where we're talking about zoning concerns, how these are regulated, what are the issues, how do these impact rural communities, different types of communities, what powers do municipalities have to regulate these? That's kind of where we're going with these and with this section. And one of the first questions that really comes up here is, you know, how are these uses characterized? You know, are short-term rentals, are they commercial? Are they residential? Are they a hybrid? And, you know, truth be told, you know, this kind of caught a lot of communities off guard because there definitely is a business aspect of these, and they definitely have a character different than standard residential uses. Well, first of all, the business aspect, you do have, you know, a property owner running this as a business, you know, renting it out, having guests as customers. There's a different type of relationship of the occupant to the property. And, you know, but in other respects, the guests are using the property similar to a manner that any long-term resident would be. So it's kind of a hybrid approach. And so when, you know, you have a code that hasn't been updated in a long period of time, and definitions don't specifically address a use that has sprung into existence because of technological changes, then you're relying on interpretation of provisions of the code that don't directly deal with the issues. And then you deal with principles that, you know, in many cases work against the municipality. Now, typically, when you're a municipal code enforcement officer, or you're a planning board, or you're a town board, and you're interpreting the code or implementing the code, when a court looks at what you're doing, you're generally entitled to great deference. So the court's not going to second guess what you're doing as long as you looked at it, as long as you have a rational basis for what it is you're doing. But there are certain circumstances where that's not the case. And one of those is interpreting the zoning law where you have a circumstance where it's a matter of what we call pure legal interpretation, where the law restricts you in some way, and it's a matter of interpreting what the law says. And, back a long time ago, zoning wasn't a thing. Zoning is, started in the early 1900s. It was, it kind of, grew out of the fact that as we started to, increase population and live closer together, that there was a need to kind of deal with the issues that came with that. But before that, use of land was generally limited to as long as you didn't commit a tort against your neighbor, the law of nuisance. So when zoning came to be, it changed that dynamic. And so it went against the old common law. Now there's a doctrine where if you're interpreting zoning laws against somebody as the municipality, they're construed against you as the municipal enforcement officer and in favor of the property owner. So that's a point to consider. So in many cases, that could cause problems where you have a code provision that doesn't squarely address certain issues. And an example I've given in the past is, public utilities. We've seen in many cases solar projects spring up across the state. And many of these codes have, from the 1960s were drafted, have a provision that allows public utilities in every zoning district, including residential. And the question is, well, when you look at that definition, doesn't the solar facility comply with that? And then, that's when you apply that legal principle, zoning being in derogation of the common law, it's construed against the municipality, then you have an issue. So those are the types of dynamics we're entering into. You have codes that haven't been updated, a new use, and then we're moving forward. So what is the powers that a municipality has to regulate, in general, and regulate these issues? Well, first of all, we all know the municipal zoning power regulating the use of land. A municipality has police powers, the ability to regulate the community to protect the health, safety, and welfare. There's also specific authority in different provisions of the law, specific statutory grants to regulate these specific types of uses. So those are the sources of municipal power. It's important to note when evaluating, how broad of the authority there is and what you can and can't do, is that zoning is a legislative act and they enjoy a strong presumption of validity. So when I say strong presumption of validity, it means that as long as it's done in a rational way, that it's consistent with the community's comprehensive plan, which is, again, very broad, that anybody challenging that ordinance would have a very heavy burden to meet. So odds are that as long as there's some reasonable basis for what you're considering and what you're doing, that a court would uphold it. So let me start with, I mentioned at the beginning that kind of we've been through the trenches on this. I'm going to kind of go through kind of what I call a real life zoning saga with these short-term rentals. And I'm going to go through the, kind of some experiences and how things have played out. And we're going to kind of walk through it and highlight some principles. And maybe we can kind of glean from this situation how things play out. We'll review some case law as well. But here you had a situation where you had a single family residence, you had a resident living year round, family, getting up in the morning, going to work every day. And then across the street, you had a single family residence that was rented out, short-term rentals. And then right also nearby, there was a 4-unit apartment building that was also rented out, 4-unit short-term rentals. And, what we talked about, is this commercial? Is this residential? Maybe it's a hybrid model. Well, as part of that hybrid model, the people who are frequenting those areas, most of the time they're on vacation. So they're there to have a good time. They're staying up late. They're, enjoying themselves. So there's a different, not only is there a different relationship to the property, but, the people there are usually, not, getting up for work in the morning. They're more likely to, be having a good time, depending on the circumstance. And again, not all this is the case all the time. Some people use Airbnbs on business trips, but generally speaking. So here you have a circumstance where nearly every night you have these people circulating into these areas, and you had a complaint filed by the neighbor, and you had some of the issues that were dealt with here: noise, there were parked cars, trespassing, debris was being thrown around. And the question was, is the use allowed under the zoning code? Alicia, could you just pick up for me real quick?
No problem.
Yep.
Okay, so with this one here, actually, let me share my screen just so I can advance the slides. Where were we? Here we were. Okay. So as Chuck said, the neighbor had filed a complaint. There was the typical short-term rental issues. Let me make sure my volume's nice and high. The typical short-term rental issues, the noise, the trespassing, the debris, all that kind of stuff. So the question was, is this allowed under the zoning code? Well, the residential zoning district in the municipality said single-family dwelling. That's what's allowed. What is the code? How does the code define that? Okay, so let's see. Any building or portion designed or used exclusively as the residence or sleeping place of one or more persons. Okay, and then dwelling unit was similarly defined. Residential unit, other than a mobile home, 1 or 2 rooms, including, cooking and bathroom, designed for a unit, designed as a unit for occupancy. So where did that leave us? So, okay, let's look at prohibited uses. At this point in the code, they're looking at the prohibited uses, any use not specifically listed as an approved, as of right, or specifically permitted use. Okay, what did it say about tourist homes? They required a license. So tourist home being any private dwelling used as a residence regularly or seasonably that offer overnight accommodations to tourists. And then same thing with uniform code compliance. No change could be made on the nature of the occupancy of a building unless they got to see about authorizing that change. So what happened here? So basically, looking at these sections to determine compliance, was it a dwelling unit? Was it prohibited? Did it require a license? Things like that. So that was something that was at issue in that case. So as far as code interpretation, so this was a big problem and as what Chuck called the zoning saga is, okay, we can determine, or one side can argue this was a dwelling unit, this was a tourist accommodation. Versus something else. Well, how do if we're going to fight over that, who actually interprets the code in the first instance? So this
I'll take it back from you, Alicia.
Okay.
Thanks.
Yeah, no problem.
So essentially, what you had here was you had code provisions that had not really been contemplated at the time for this specific use, and so. What you're talking about here was you had this old definition of tourist home. You had, you had the standard definition of prohibited uses. Okay, you can't do anything that's not specifically allowed. You had a provision that said you can't change the use without, a change to the certificate of occupancy. You had like residential zoning districts that allowed single family dwellings. You had the standard stuff. Okay. So that, in many cases you'd think, well, you should only have residential uses here. So you can't have a business use. You can't have a hybrid use, which is what a short-term rental would be. You can only have single family dwellings. You can't have a tourist home because the code defines tourist home elsewhere and has licenses. So there was all this information that, while not directly addressing the issue, indicated that there might be some issues. So who interprets this in the first instance? Well, let's back up for a second. Generally, where there's a complaint or a violation, or where somebody's requesting an interpretation, it goes to the code enforcement officer. And the code enforcement officer then gets appealed to the Zoning Board of Appeals. And the Quentin case that we cite to and rely upon in the papers is just an example of that. It goes, the building department or the building inspector or the code enforcement officer makes the determination. And then it goes to the Zoning Board of Appeals for review. And the Zoning Board of Appeals in the community has the final word on what the zoning law says in the community.
Chuck, if you could reshare your screen. When you jumped off, we switched it around there. So we're not actually seeing your share anymore.
Oh, okay. I apologize. Sorry about that. Let's see. I should have asked for the thumbs up. Okay.
So we can see your desktop right now.
Bear with me one second. How about now?
Yes, now we can see.
Okay, thanks. Sorry about that. So the Zoning Board of Appeals is then the final word on what the zoning law means in the community. And an aggrieved party may challenge that determination via an Article 78 proceeding, or may seek deviations from the zoning law through an area variance or a use variance. Let's take a look at some case law with respect to short-term rentals. This case, you had petitioners who owned lakeshore property in the town of Arietta. The property was located in a single-family residential zoning district. The structure was located, was a 6-bedroom residence. Petitioners brought the property in 2009, and then they started advertising it and marketing the property for short-term rentals. They joined the Chamber of Commerce. The neighbors then complained about it. The zoning enforcement officer determined that petitioners were operating a tourist accommodation in violation of the zoning code. The Zoning Board of Appeals then affirmed that determination, and then the petitioners commenced the Article 78 proceeding to challenge that determination. And then the court noted what the standard principle was that I reviewed. Although a reviewing court typically will grant deference to the ZBA's interpretation, disturbing that only if irrational or unreasonable. Where the issue is one of pure legal interpretation, deference is not required. And where zoning regulations, being in derogation of the common law, they're strictly construed against the municipality, which has enacted and seeks to enforce them. And any ambiguity in the language used must be resolved in favor of the property owner. So here, the town defined the single-family residence, which is pretty standard, as a detached building, not including a mobile home, used as the living quarters for one family, and also includes seasonal cottage. And tourist accommodation was defined to kind of include hotels, motels, resorts, tourist cabins, or similar transient facility. And the third department found that because that the zoning board classifying that use as a tourist accommodation was didn't kind of fit in that model, that it was irrational and that it should have fit in with the single family residence definition. And they noted some of the factors in there as to why they came to that conclusion. Another case, and this is an important case. Here you had a circumstance where you had a 5-unit apartment house was being rented out unit by unit, and the zoning enforcement officer issued a notice of violation. And the Zoning Board of Appeals affirmed that interpretation, that it didn't meet the requirements of the code. And the court overturned that on the basis that the code focused on rooms and they weren't renting it out room by room. And the court noted that the code could have easily said that you couldn't rent multiple family dwellings on a short-term basis, but it didn't. So that kind of set the stage that the municipality has the authority to do that, but you have to actually do it from a legislative basis. Another case, the property owner brought an Article 78 proceeding in action for declaratory judgment to review a determination of the town's zoning board of appeals, requiring the owner to obtain a special use permit for renting out the residence on Airbnb. The court held that the owner's use of the property did not require a special use permit because it wasn't a hotel, it wasn't a bed and breakfast, and it wasn't a transient use. And it noted that, based on the code's definition of a single family dwelling, that there was no durational limitation in the code, and therefore it fit within that definition. And here's a case out of the 4th Department where the town actually dealt with the issue, amended their code to prohibit transient rentals of dwelling units less than 28 consecutive days. The petitioner owned a single family residence in a residential district and conducted short-term rentals. The ZEO issued a determination that petitioner was violating the ordinance, and the petitioner appealed to the ZBA and affirmed the code enforcement officer. And the court affirmed that determination and noted that that was permissible. So what are the takeaways? Well, as I mentioned, you can't really rely on old zoning codes to deal with these issues or feel comfortable about the fact that you have residential zones that protect residential uses and exclude all other uses. Courts have tended to side with the property owners under the standard principle of zoning being in derogation of the property owner is strictly construed against the municipality, and ambiguities are resolved in favor of the property owner. So the traditional deference that usually is given to municipalities is not afforded. But short-term rentals can be prohibited if they're specifically defined. And as you can prohibit something, you can regulate it or restrict it or limit it or put it in places where it's appropriate and limit it in places where it's not, as the community deems appropriate. But in many cases, the community is going to have to develop a comprehensive ordinance that's consistent with the comprehensive plan. And in doing that, kind of reviewing some standard zoning principles, I think may be in order. One of those principles is, what is kind of zoning about as far as what you're regulating? And sometimes, that line gets blurred. What you're really regulating is the use of land and limiting the impacts from that use of land on the community. It's not about the owner. It's not about, who owns the property, who's using the property, the identity of the owner. So it's not about the operation of a business per se. So one of the cases that kind of just discusses that is the Bone First Grill case. There you had a variance that was granting a parking deviation, and there was a condition that the parking could only be used while or the operation of the business had to be limited to when the parking would be able to use valet. And the court held that condition, while dealing with the operation of the business, was limited to a land use concern. And so the court kind of went through and noted that while it looked like you were regulating the operation of the business, it was related back to one of the impacts on the use of land, which was, appropriate traffic congestion and parking issues. Similar, there was a case, the Old Country Burgers case, which is, I think, one of my favorite ones on conditions, where, there was all this litigation over a drive-through, and finally the drive-through gets approved, but it was conditioned that you couldn't use the drive-through during mealtime. And that got challenged, and the court kind of found that regulation was regulating the operation of the business and not necessarily the impact of land. So it can be a fine line. And one of the fine line cases was the Village of Victor case, where the village prohibited the formula fast food restaurants. So they prohibited this certain type of establishment that was defined as any establishment required by contract, franchise, or other arrangement to offer 2 or more of the following: standard menus, uniforms, etc. Basically trying to get rid of franchises. And interestingly, the court held, and I would have thought that was definitely regulating the operation of the business, but the court found that had a valid land use concern involved in community character. So that, so the line can sometimes be hard to pinpoint and pin down. But the interesting thing to note is that, that line is probably going to be similarly blurred with short-term rentals, because a lot of the operational issues that we're going to talk about things you might want to look at regulating are going to, impact the use of land and the impacts from those. So zoning in this case, you're probably going to, diverge a little bit more into operations maybe than you would typically in other uses. Non-conforming uses, the non-conforming use problem. So I'm going to touch on this just briefly, just to review. Non-conforming uses generally are when you have a use that's legal at the time, when you make it illegal, you're allowed to continue that use. And there's a constitutional right to do that. Now, those uses, although lawful, are disfavored, and you can get rid of them. And I'll try and move through and get through this item quickly, but the point here to note is that the key on getting rid of them, if there is a non-conforming use, is that the amount of time you give the property owner to recoup their investment has to be reasonable in light of the circumstances. So when you amortize a use out, they have to be able to have a reasonable opportunity to recover their investment under the circumstances. And you can provide for administrative remedies for extensions and look at the facts and circumstances in a particular case. So if you have a circumstance where you have short-term rentals going on and you haven't prohibited them and you want to look at limiting them, you can amortize them out. And you can offer an administrative remedy to say, look, if you haven't been able to recoup your investment, or you feel like, there's been some unreasonableness, you can apply for an extension, and then you put the burden on the applicant to demonstrate that they need some additional time to recover their investment. And then you kind of give an administrative remedy that needs to be exhausted before judicial review. But non-conforming uses can be amortized out of a community. So when you're developing your regulations, here are some initial questions I think that everybody's going to want to ask and need to be answered. Is, do you want them in your community? Some communities don't want them at all. We've represented a lot of communities that don't and have banned them, and you can. Other communities rely on tourist funds and tourism. So what types of short-term rentals do you want? Do you want bed and breakfast? Do you want to have an owner present? There's different impacts that are at play when you have an owner on the property. Where do you want to locate them? What zoning district? What kind of density do you want? If you allow them, how are they going to be regulated? How should the regulations be enforced? What does your comprehensive plan say about the community growth patterns? And what do you want to do with the existing operations? Do you want to let them continue? Do you want to amortize them out, et cetera, et cetera? So in general, this is probably the case for any law, but you want to develop findings, and then you would adopt the new regulations, and then you'd want to be specific as to how you're treating short-term rentals. Have a clear definition. Make sure it's very well understood. You'd also want to have a fee structure to address these issues so that you can administer and enforce the program and it wouldn't drain from other resources. The Jewish Reconstructionist Synagogue case kind of lays out the power to impose municipal fees to offset costs to administer and enforce a municipal program. It has to be rationally related to the costs of doing so. So it's not a money-making adventure. It's, is there a rational relationship between the cost of the program and the fees being charged? And then determine how you want to utilize the municipal authority to regulate this use, because there's a lot of tools that you have. One of the comments I think I saw was about overlay districts and the ability to have a legislative rezoning to rezone an area where these are allowed in the community. Yes, you can do that. You can also, put them in certain zoning districts and restrict them in others. You can also regulate them by special use permit. I don't know that site plan is necessarily appropriate for this particular use, but for parking and other things that may come up, that might maybe a simplified process would be appropriate. Licensing is another option, or some other types of approvals would be appropriate, but that's something to be fleshed out as to exactly. The other issue is which board would be best equipped to review these and handle it in your particular community. The legislative body wants to be the one to do it, the town board or the village board, or others, the planning board, others, the zoning board of appeals. So you want to have some application requirements or a form or a process or documentation that's necessary to start this up. Consider whether you want to have a residency requirement. Instead of allowing this to anybody to have title to vacant homes, allowing it to people who have primary residence who want to, rent out their primary residence that live there most of the time on a case-by-case basis. Cap the number of days it can be rented as short-term rental. Make sure you address parking. All those issues. Designate a local contact person. Include noise and nuisance provision. Deal with garbage collection issues. Maybe require minimum spacing between other short-term rentals, so you don't have one area that's just totally inundated. Or, you could take the other approach and say we want to have a district that only has, or an area that only has the short-term rentals, depending on what the circumstances of your particular community need are. Notification requirements for neighbor, that to me isn't necessarily a great one, but I've seen it. It generally causes issues. Limiting the number of guests, limiting the number of turnover, all those things. Enforcement on these, I can tell you, can be a real struggle because, there's personnel limitations and a lot of the problems happen off hours. At night, it can be difficult. And a lot of the noise issues, nuisance issues, there can be difficulty with enforcement. So, ensuring that, you go through a rigorous process and that you vet these at the beginning, and that you have the mechanism in place to, bring in violators and revoke, permits or licenses following due process if there's violations is key. And then there's always the ability of an applicant to seek variances if they are told no, and they're able to do that. And so be prepared for those. We've had a lot of variance applications, a lot of interesting variance applications, and a lot of litigation over these types of uses, and ultimately Article 78 proceedings that have resulted from those. But when you have a use variance determination or an area variance determination or whatever, and you go to an Article 78, that's where you're in, and you do have a solid record and you have a rational basis for your determination. That's where your municipal deference comes back into play, and courts will defer to the judgment of the agency. And I included a last case on Article 78 proceedings, but it's off topic. I'll leave it there for your enjoyment. And with that, I think we can, Doug, go through any questions that have appeared in the box.
Chuck and Alicia, thank you both so much. It's such great information. I can tell you, as our community of the town of Canandaigua, we have over 260 short-term rentals in the town of Canandaigua. And I think, Chuck, you hit the nail on the head when you were talking about each community having to make a decision on what it is that is best for their community, right? And really get into the nuts and bolts. I know for our short-term rental regulation, when we did ours, I think we debated it almost 2 years and kind of came down to basically a registration type system, because we were facing issues where basements were converted into bedrooms without points of egress and failing septic systems and all those types of things. So each municipality's kind of got to wade through that. So if you have time, I've seen a number of questions here. I guess what I'll do is I'll read them to you, and if you want to kind of bat them around, and then we can kind of talk about them one at a time here. So if a municipality adopts a new short-term rental ordinance that restricts rentals to a defined area, can it be written into the ordinance that existing short-term rental operations outside the defined area that were grandfathered at the time of the ordinance cease to be allowed in a change of ownership in the future?
No. I would not do that because zoning is not about who owns the property, as I mentioned. What it's about is the use of land. You can say after a period of time it's going away, but you can't say that when it changes ownership. If the way I would handle it is I would say, I'm going to give, we're going to give you a reasonable opportunity to recoup your investment of 5 years or something, and then you can apply if you have evidence that you haven't recouped your thing after 5 years, you can have 3 more if you meet the standard, and then lay out like essentially factors similar to a use variance, and then give the ZBA the authority to review the application. But when you make it about changing of ownership, that kind of creates other issues. You may be able to make an argument that, well, if somebody's selling it, then it really changes the investment expectation. But I'd have to do more. I'd have to give that more thought as to how I would approach it before I would say, yeah, that's a great idea. So my gut instinct would say not to create it that way. I would do it with a period of time, and I would not tie it to who owns the property.
Okay. There's a question relating to HOAs or lake associations, and are they successful in regulating short-term rentals?
Yeah, they are. So they have different authority. It's contractual authority. And essentially what happens there is you've contracted through your deed to follow the rules. And, if you've agreed to follow the rules of the HOA and the HOA tells you can't do it, then if you do, you can suffer the consequences of the HOA through the law of contracts. So that's not a municipal issue. Municipalities don't enforce those.
Right. Another one, what about suburban or rural uses like short-term rental of campers, trailers, RVs, tiny homes, tent sites? Also, what about non-residential units like day use of beachfront or property for an event? Could those be regulated through short-term rental?
All of those can be regulated.
Okay. If you have an opportunity and time, do you have any examples of decisions interpreting use of zoning codes to restrict? I think you kind of probably already went through a lot of that in your presentation. Yep. Next question, I'd be curious to see how this would translate over to rural communities and small towns that are looking to encourage these types of uses. There's a reference to the cities being more densely populated, and are there minimum aspects that should be included in the regulations?
Well, if you want to encourage them, don't regulate them.
They'll just kind of happen, right?
Well, I mean, think about it, right? I mean, anything you regulate is going to put a burden on them, right? And if it's rural and everything's spread out, and they're not a problem.
Right. There's a couple of questions here, and I'll summarize because a couple of them relate to each other relative to occupancy tax. I know for the town of
I'm sorry,
Canandaigua,
what?
for occupancy tax,
Oh, yeah.
I know for us, for the town of Canandaigua, we decided not to do the occupancy tax piece. This is just a registration. Again, I guess that goes back to each community needs to decide what makes the most sense for them, right?
Yeah. I mean, first of all, like, you know, my understanding, and I'm not a tax lawyer, is that uh, unless you have a legislative act saying you can tax and you're not the state, you can't. And I don't think towns and at least towns have the ability to tax hotels. I believe in I've dealt with this in Erie County. The county does, but towns don't have, in Erie County don't have the power. I don't know about cities off the top of my head, but I do know that where you have problems is you've had a lot of these things that were subject to taxes not paying early on. And so that was a big problem with these because they were unfairly competing with other, similar uses because the hotels would pay. And that's changed because now I think Airbnb has recognized that as a potential threat because they were being targeted, and so they collect it now and remit it on behalf of the hosts. Alicia, if you have something that that I don't, go for it.
So I was just going to say that that's Airbnb has kind of stepped in and helped hosts with that because it's become more popular. Yeah, absolutely.
There was a question, what is the rationale basis for establishing a 30-day minimum requirement for short-term rentals? I don't know if one of you would just want to touch
There's a
on.
million rational bases, but I'll give you a couple. First of all, as I mentioned, this is not a residential use, right? It's different than that. It has a different character. You don't have the same level of approach toward the property. You don't have the same level of care. You have different people living there. So, uh, every single day you have different people treating different, they treat the garbage differently. They don't know the boundaries of the site, so they're more likely to trespass. So there's a lot of, that's just a couple right there. And they're likely to be louder. So, it's a different character of use, and they have different impacts, and they have different impacts from a short-term rental use where you have an owner on the property, right? Where you have an Airbnb and the owner of the property is there, the guests behave much differently. They're not in the backyard at 2 a.m. hooting and hollering or building the bonfire and staying out until 5 a.m. It's just a different situation. So that's the rational basis right there. And all you have to show for a rational basis is that there's some difference. It doesn't have to be even that significant. It's that there's some reason to treat them somewhat differently. And findings have been upheld along those lines by courts.
I see a number of questions here that kind of relate to enforcement issues and even getting compliance and those sorts of things. I don't know if you have any thoughts on that you'd like to share. I know I can tell you what we did. We actually put our law into place, and it was on the books for a year. And during that year, we had 5 homeowners that complied with our law where they voluntarily registered essentially for the short-term rental. And it wasn't until we started using one of the many companies that we had just this onslaught of these other 255 short-term rentals that were already happening in the community that went ahead and started to register with us. I don't know if you have had any experience along that or thoughts on that.
So, not a registry per se, but as far as how do you enforce it? I see one question is how do you show the guests are staying in less than the time frame? Well, first of all, you have advertising going on where they're offering their property for rent for the shorter period of time. So if you're looking on enforcing, you don't necessarily have to find that a guest stayed there necessarily. You have to show that they're offering their house for sale, and that alone is using it for that purpose. So that's one thing, and but other enforcement avenues is the neighbors can be very helpful witnesses as to what's going on, and photographs of license plates there one day and then different license plates there the next day, or this car with these license plates are here for these 3 days, and then there for that 3 days, and all that. So those are just some issues that have come up.
Awesome. I think we've answered the majority of the questions. Alicia and Charles, Chuck, thank you so much. It's so informative, very, very helpful, and just fantastic information. And there's so many municipalities that are dealing with this issue right now. We will have the information available through the website. The next session is Exploring Today's Housing Crisis and Exploring Solutions, coming up on October the 20th. At 12 o'clock, and we look forward to everybody joining for that session. But Chuck and Alicia, thank you again for taking all the time today and going through this with us. We really sincerely appreciate it.